Folks, this is House Corrections and Institutions Committee. It is Wednesday,
Welcome back.
April 16th. This is our morning meeting at 9 o'clock, and we are taking some testimony on H 379. Last week, we had a walkthrough of the bill from our legislative council. We haven't decided how much if we're really gonna work on the bill or not, but we wanted to take a little bit more testimony before we made that decision. So let's start off this morning with the sponsor of the bill, Representative Eric McGuire. And Eric, welcome to your old committee.
Hello. Thank you very much, Chair. For the record, yes, Representative Eric McGuire, Rutland City, Human Services Committee. Good to be back, and I appreciate everybody's opportunity and time that they're going to be spending today within this bill. I really want to be brief so I can turn it on over to Dr. Prasani Reese, who is without a doubt the foremost expert in these initiatives. With her agency, the agencies that she works with, they have the ones that have developed the Second Look initiative, which I am very, very supportive of. Main reason why is that this is a very, very balanced approach. And what I mean by that is that the cost savings and the money that also gets put into like victim initiatives, supporting victims in their roles, laying things out in a very practical and applicable manner. This is not a get out of jail free card. This is not everybody can apply after 15 years and there's automatically an answer of yes. There is a significant process that needs to be completed. There are things that need to be accomplished. There is a lot of assessments, understanding, facts involved in this initiative. So with that, I just want to be brief and allow Dr. Prasani Reese. And again, thank you for bringing in the expert in this to give you the facts, the true understanding of this initiative. And I hope everybody will be very responsive to it. And we do have an opportunity to become one of the few states that do push this on through, because over time also, this reduces significant unilateral and collateral costs upon the taxpayer as well as upon the system. So thank you very much.
That's quick. Thank you, Eric.
He's changed.
I'm smart enough to recognize when you got the smartest person in the room on the matter.
No.
Get out of the way.
You did hit every buzzword, so.
So Dr. Reese, welcome. So if you could also identify yourself for the record.
Of course. Good morning. My name is Dr. Prasani Reese. I'll do a little more introducing myself once I get my
Your bearings.
screen. Yes, get my bearings. Everybody can see, yes. Okay, great. Okay. Good morning, everyone. Good morning, Chair Emmons, Vice Chair Troiano, Ranking Member Morrissey.
Well, that's an old one. That's cute.
I already messed up. Rep, you're gonna have to kick me out.
This is his whole
No,
committee.
we don't pick people out, we make them stay longer.
Yeah, this is
No,
that's an
punishment.
representative for it's true.
I love this. Thank you. Thank you so much. Well, thank you for welcoming and esteemed members of the committee. I'm really honored to be here. My name is Dr. Prasani Reese. I'm the Executive Director of Dropout Up New England. I want to begin today with a personal story. When I was in my early 20s, I survived an attempt on my life at the hands of a romantic partner. I was choked. I was dragged by my hair. I was pistol whipped. As I was losing consciousness, I saw my body in the Charles River. The only reason I survived is because he let me go. He was a lot bigger and stronger than I was. But his subsequent incarceration did nothing to bring me healing. It did, however, put me on the path that brought me here for you today. And for that, I am grateful. Today, I hold the doctorate in clinical psychology, dual specializing in forensics and children. I have studied dangerousness and violence for the last decade. I'm also a trained restorative justice facilitator, which did actually help bring me here. I want to thank Representative McGuire for making this bill a possibility, and I want to thank the committee for this discussion today. without further ado. In this presentation, I will give an overview that includes Second Look Defined, the problem of life sentences, a focus on Vermont, associated financial costs, an overview of Second Look legislation elsewhere, because this is a movement for sure. I will then conclude my presentation, and I'm happy to take questions from the committee at any point during the presentation, so please feel free to interrupt.
This is a really basic one. I don't know what LWOP is.
Yes, life without parole,
Thank
life
you.
without the possibility of parole. Let's dive into the definition of second look. So second look is defined as any legislation that authorizes judges to review sentences after a person has served a lengthy period of incarceration. Second look is colloquially referred to as sentence review because that's all it is. It's simply a review. For the bill drafted here in Vermont, the eligibility would require 15 years served before one can even apply. And this underscores the thoughtfulness that is required in assessing a person who has been convicted of a violent or serious crime. If the hearing is granted, and the if is important, the individual must demonstrate both remorse and rehabilitation, among a variety of many other factors. It's ultimately in the judge's hands to decide whether or not their sentence will be reduced. It may be reduced, it may not be. It is not release, as Rep. McGuire emphasized. Now let's explore why a second look is necessary. Why is this a movement across the country? In all 50 states, we are witnessing a problem, a relatively new problem, an aging prison population. This is relatively new because it's caused by the rise in life sentences. Now, second look is not explicitly for individuals who are serving life sentences, but it's evident from its design that it is intended to help people who are serving lengthy sentences, including life sentences. As members of this committee are aware, there are three kinds of life sentences. Life with the possibility of parole, meaning a person will see a parole board after several years, few years, a lot of years. Life without the possibility of parole, meaning that the person will die in prison, regardless of the number of years they have served. And virtual life, which is defined as a sentence as 50 years or more. And research has shown that that most likely will ultimately lead to the person's death in prison as well. The origin of the issue of the aging prison population has its roots in trends that started 40 years ago. In general, this shift occurred for two very simple reasons. One, we started sentencing way more people to life sentences. And then two, stopped letting them out. This chart from the Sentencing Project illustrates the trends since the early 90s. You can see in 1992, we had 57,888 people serving life with parole, 9,404 individuals serving life without parole. By 2020, the numbers have skyrocketed. Life with parole is at 105,567. Life without parole is 55,000, just shy of 56,000 people. And virtual life sentences, as indicated by the light green, that's a phenomenon that started getting tracked by the Sentencing Project in 2016. You can see in 2020, 42,353 people. It's important to note that although it's not represented on this chart, in 1984, which is 2 years after I was born, there were only 34,000 people serving life in all three of those categories.
So let me ask a couple of questions here.
Sure.
Back in the early 90s, we were seeing an increase in overall incarceration to begin with. That was three strikes you're out, was one of it on the national level. But also there was a move in the country, and there also was here in Vermont, for deinstitutionalization of our mental health system.
Yes.
For folks to, the theory was move them out of an institutional setting, beef up the community system. And we were seeing an increase of folks being incarcerated after that. Do these numbers reflect any of that?
Yes, absolutely, because we believe that the mass incarceration funnel, if you will, was the result of several different types of laws that swept the country, including several types of laws that swept the country coupled with the deinstitutionalization of our mental health hospitals. Yeah.
Because that's when in Vermont, we started really seeing an increase of folks being incarcerated as we were deinstitutionalizing our mental health system in our state hospital. You can say you're going to deinstitutionalize, but you are institutionalizing in a different setting. This is totally inappropriate. And that's what we were starting to see. The increase in folks being incarcerated in Vermont was due to the mental health issues. The other question I want to ask is, this is data from states. Does it also include Vermont or not? Because the data from other states, they don't have a mechanism in most states called furlough, and we do.
Right.
So is this just data from other states because they're incarcerated? And the next step for folks who are incarcerated in other states is parole. For us, we have incarceration, then we have furlough, and then we have parole. So do these numbers take into account anything within our system with the furlough piece?
Not this, so this is very broad. I figured I would start very broad and then we'll like work down into Vermont. Because this is the Sentencing Project, which is a national organization, is attempting to capture the phenomenon, which I think they capture very well, which is that our trend of life sentences has a very stark, steep incline.
Questions? Kevin and then Brian?
And along the same line, inclusion of the institutionalized is one reason.
Yeah.
Are you going to address what you think the reason for the uptick is in this presentation? Or should I ask, what else is causing this increase? Because the population is generally staying stagnant or even dropping.
Right, yes, and we'll move into Vermont and talking about, there has been a decarceration effort around the country that has actually been quite successful.
Yeah.
I say to people now, we don't have a mass incarceration issue, we have a life sentencing issue.
Okay.
Just different.
So sounds like you're going to.
We'll talk a little bit about that, but
Great.
please poke me if I don't
Thanks.
get to your question.
We have another question here, Brian.
Well, and like Kevin, if you're going to get to it, you're going to get to it. But the two questions are, does Vermont show the same trend? And then is this due in part to mandatory sentencing?
All of this, yes, everything is captured in this very broad. So everything that you see here in this chart is laws that over-criminalize, mandatory minimums. Like in many states, for example, life without parole is a mandatory sentence for first-degree homicide. So then you are obviously going to see an uptick in those states.
Cool. And then we show the same trend as the national trend here.
Yes, but we'll talk about present-day Vermont, which again is a very positive place to be. I'm excited to be here in Vermont. Just a quick, this is the most recent version of the chart. I just want to highlight this because it illustrates that our life sentences and our use of life sentences has remained consistent, even though, again, the country has been significantly decarcerating, but they are not decarcerating their life sentence population. If you looked at 2003 forward, you would think that a very large life population is the norm. But we know from this issue that we're dealing with of the system not being able to take care of elderly people and things of that nature, we know that that means it's not typical. Prison systems were not developed to be nursing homes. Okay, let's talk a little bit about Vermont. A couple of things I want to point out to the committee before I start, because on second look on page 1, there are some statistics that I provided to explain the rationalization of the bill, but some of those research reports have been updated. So now some of those numbers are outdated. What I'll talk about today is the most current research trends published in January 2025. So hot off the presses, and I did bring copies of those reports for the committee's review. Here is a breakdown of life sentences in Vermont. Life with parole, you can see at the top chart, there are 170 individuals serving life with parole, 14 serving life without parole, 28 virtual life, totaling 212 people.
So can I interrupt there? Do you know what their conviction was?
Which crimes?
Yeah,
I do not.
that would be something, if we want to work on this, would be very helpful for the committee to know what their convictions were
Thank you. That's good to
and
know.
what the length of sentence is.
Can get both from city, right?
If you move to the chart below and to the left, you'll see the same groups, but broken down in a different way. Now we're looking at those who are considered to be elderly inside Vermont DOC. Elderly is 55 years or older. I know that you see that. It's not meant to be offensive, but it's definitely not a typo. We know from the research that for every year a person is incarcerated, they age 2 years. For a variety of reasons, but as of right now, that means that 41% of the lifer population here is elderly by medical standards. And with each passing year, this number could grow quite quickly because we don't know where the rest of this cohort is in their age timeline. And the trend, unfortunately, of incarcerating for life sentences here in Vermont persists. This chart, again, was published in January 2025. It was created by the Sentencing Project, and it illustrates the percentage change in the life sentence population from 2020 to 2024. It ranks all 50 states by their ranking percentages. On the right, you'll see the zoom in I provided for you here, highlighting that Vermont holds the third highest position for the percentage change, having added 27% to its lifer population in the last 4 years. Based on the current population, that would be about 57 people. And I think to the chair's point, it will be helpful to understand who those individuals are.
My hunch is the bulk of that is changes that we made to sex offenses.
It will be interesting.
And also the sex offenses.
Six.
And that is a result of, and I don't remember what year this was, it was the murder that happened at Brookfield of Brooke.
Yep.
Because we increased sentencing there. And sex offenders typically are older folks to begin with. They're not your 20-year-olds, 30-year-olds. They're mostly your 40s, 50s, 60-year-olds. That's the other piece here. I think we as a committee should do a little deeper dive.
Absolutely.
Really see what's happening here.
Thank you for that.
It's just a hunch, just based on what we've been working on over the past 20 years.
Makes sense to me.
I have a dumb question.
It's not done.
Oh, it might be. Okay. There are dumb questions, and I have a few. So is this just the change? So let's just pretend so we can use real numbers, right? They're not real numbers. Say we had 100 people that were sentenced to life. And now we have 126, so it's 26% change. Is it that measurement, or is it the percentage of people under life versus the total population?
No, it's that. So
Okay.
we take the base population
Okay.
and then how much have you increased in the last 4 years? And they did the percentage calculation. Yeah, exactly.
Thank you.
Yes. Let's delve a little bit into the issue of aging in prison and examine why the implementation of Second Look policy is both practical and research-based. The core issue revolves around the phenomenon of individuals aging out of criminal activity, yet remaining incarcerated far beyond the point of dangerousness, eventually leading them to age into incapacitation. Now, this may or may not be physical incapacitation, but once they have reached a certain age where a nursing home or a similar placement is required, I think everyone in this room knows how difficult that is to find a way to get that person out of prison and back into the community. But for most people who are incarcerated, there are many years in between the young and potentially dangerous and the elderly and infirm. And Second Look is targeting those transitional years. Now, again, in Vermont, you have to wait 15 years. But there's usually a significant time gap for most people where we could take a second look and review their sentence. This is how Second Look is distinguished from compassionate release, because we're targeting those middle years, whereas in compassionate release is about the elderly and infirm stage, and Second Look is about the can we get them out of prison before they are elderly and infirm. first, the concept of aging out of crime, and I know that this committee is very familiar with things of this nature, but I think it bears repeating because it is a longstanding and well-tested concept in criminology. Individuals age out of criminal activity for a range of offenses. So I happen to pick murder and robbery here, but we have other charts that are very similar that basically show the peak level of dangerousness, quote unquote, of a person around their 20th, 21st birthday, and then a decline by the time they hit 45, 50 years old, they're significantly likely to be involved in criminal activity. Now, this is a naturally occurring phenomenon. So this is not about our incarcerated population. This is just about people in the community who may be engaging in activity. So it shows a natural drop off. But let's talk.
Does this also show women or is it just males? Is it just men or does it also show the graph? Does that also
This
include women or is it just males?
It encompasses everybody, just that women are a small portion of it, but yes. I think when you separate the genders and we're doing risk assessments, you can find variation between the genders. Yeah, and it's a good point.
And
Kevin?
I'm sorry,
No, go ahead.
over what period of time is this data taken? I don't see this. Is this, 1990 through 2010?
Yeah,
I see.
there's so much on the screen that I always want to make bigger so that everyone can see it, but
I got it
yes.
now. Yep. 20 years worth of information. Yep.
And this, even though it's 20 years worth of information, criminologists have been studying this for now, we're going on 50 years worth of time, and that trend hasn't changed.
And it mirrors just any common sense things we know. I mean, like a 20-year-old guy has more of, just to make it easy, rage than a 45-year-old man. It's like this natural, you know, doesn't mean you're criminal, but like you definitely have more passion. Let's go with that. Then yeah. So
watch out.
That's lack of wisdom.
Lack of, I mean, there's so much, you're right, though, right? I mean, you're young and dumb is what my husband would say.
Too.
That's it.
in basic terms, it's relatively true. It's biology. It's
Yeah, no, I,
Brain has
completely.
what you do with that, what behaviors you exhibit, but is it more naturally inclined? So anyways.
Yes, well, and you're more inclined to do what your peers are doing
Mhm.
at that age too, which also influences all.
So
of
at
us.
most of our age, that's math.
I vote for no. So you might be thinking, okay, people age out of crime, but can we talk about risk? Because public safety is an issue. It's a very, very extremely important issue. And you might be wondering, well, aren't life sentence populations more dangerous to be released? And Chairman's already knows where I'm going with this. But I would like to present a relevant case study because it's a perfect encapsulation of what we know from the research. This is a collective known as the Ungers. You might have heard of them, I'm not sure, but 188 people serving life. They were in Maryland. There was a court case. The case was overturned, which automatically allowed them all to be released at the same time. So a perfect research study for us. They were released in 2012. And when they had been released, on average, they had been incarcerated for 40 years. And they were averaging about 64 years old at the time of release. According to the Justice Policy Institute, who followed them and tracked them, only 5 have returned for either parole, technical violations, or new offense. This would be the equivalent of a recidivism rate for this group of 2%. Which is well below Maryland's overall recidivism rate of 40%. And when we pull apart lifers and people who have served extreme sentences in this way, we tend to find this kind of repeatedly over and over. And you all probably know, you've talked to correctional officers, parole officers, probation officers, and I bet a lot of them say that their lifers are their easiest clients.
So could you give an example of technical violation? Because we have some new members to the committee who are new to corrections,
Yeah.
new to that world. So they're out on parole. What would be a technical violation?
Drinking when you're not allowed to be using drugs.
That's a condition of their release.
Exactly. Yeah, that's often drugs and alcohol prohibition. is often a part of the release. But my favorites are things like you went outside of a certain area. So that may be relevant for certain cases and certain activities, but we have seen people, for instance, who are construction workers. They come out of prison, they're welders, they go to a job site, that job site is teetering on the edge of their whatnot. They've told their parole officer, but then their GPS won't stop buzzing. Their parole officer gets a phone call that says, go pick them up, they have violated their parole. And that parole officer, if he or she is worth their salt and has a good relationship with the client, they will not go and pick them up and reincarcerate them. They will give them a call and say, hey, I'm going to stop by your work site and check and make sure that everything is good, just so I could cover my bases. But that would be a parole violation, and someone who wants to be by the books could just pick them up and take them and reincarcerate them. You may have some other ones, Chairman. No?
Examples. As well, you know, as we dig in deeper into corrections issues, you're gonna hear the term technical violation quite a bit. So I wanted the committee members to understand, because that's very different than a new crime.
Yes.
Very, very different. And when we start talking at some point with our field offices and our P&P officers and how all of that is structured, it's really important to have that basic understanding of what a technical violation is.
It's so true. It's so true.
Brian?
Yeah, it's sort of an inchoate question, but I mean, these people, the Youngers, were incarcerated decades ago, before at least some of the recent minimum sentencing rules. I don't know how many were in place at the time. So it's an obvious observation. Everybody there is a shade of brown. Once we get to the minimum sentencing, does it start to skew more white because there's less choice involved? More white people are being locked up for the same rates for the same crimes?
Across the country, state to state, within the individual states, it varies. Across the country, we disproportionately incarcerate Black and brown people. And then each state has varying levels of disproportion. Like the last time I looked into Vermont's data, like actually went into the data and checked the population, you all still disproportionately incarcerated people of color.
Yeah.
It was just at a different rate than a place that had a higher population of people of color. Still disproportionate,
Yeah.
which I think is wrapped up in poverty and other sociological factors.
Yeah. Yeah, okay, thanks.
You have another question?
So that example you painted was, I mean, that's a very sad example. I'm just curious how, you know, if we were talking about the drug and the alcohol prohibition being a major violation for release, I mean, how many times does that actually happen? That second example that you gave where someone is working, goes outside of their geographic area. I mean, is that like a very common thing, or is that just like a once in a blue moon?
You know what you'll find is that it depends on the particular parole officer. I have found that to be very interesting. Within the parole system, they know which officers, sort of at the top chain of it, they know which officers, shall we say, are a little overzealous. Right. And so that's important to have somebody who's in place for a really long time so they can then kind of manage that system. Technical violations, reincarceration for technical violations happen pretty frequently, hence the high recidivism rate, actually. Well, and that's one reason why it's hard to talk about recidivism broadly, because some places will include that in their recidivism and then other places won't.
Not us.
You don't.
For us, it's a new crime.
Yeah,
It's not technical violations.
and that's the way it should be. Yeah, in my opinion, that's the way it should be.
On that point, and to Will's point, this is, I mean, it's a little off the topic, but that's why anybody, whether it's us or potentially somebody who's out on, you know, and worried, everything in writing, everything, like, don't just your parole, hey, can I go to this job site? Yep. Well, there's no evidence now. Put it in writing, right? I mean, like, protect yourself at all costs, because there are people that are overzealous, you know, so.
Absolutely. No, and
That helps us today, but it just.
No, but I'm appreciating the knowledge in this room. It's really great to be able to talk about the system in a little bit of a deeper level.
So we have
So-
continuing
Yeah, I was gonna
questions.
say.
Oh, yes. Oh,
I have an
please.
Additional question. So now that brings up a whole different topic of discretion by parole officers. Who, or I'm assuming statute would govern that, and how narrow or how wide a
No.
parole officer.
No,
That's
it
DOC
comes from
internal
central
policy.
office.
Okay.
It comes from central office. And we have in Vermont what we call graduated sanctions that play into this. We as a committee, we just haven't gotten into that part yet because I didn't want to confuse everybody. It's a whole different world when you are supervising someone on the outside versus the incarcerated setting. So everyone here is just getting their head around the incarcerated setting. We haven't even touched what it's like when they're supervising on the outside, what tools are used, what incentives are used, how often someone may have a technical violation before they're even pulled back into a correctional facility. And it depends. If they're on furlough, it's DOC that makes that decision. If they're on parole, it's the parole board. So we haven't even gotten into that as a committee in terms of supervision on the outside.
It is a completely
It's
different.
very
world.
different.
Yeah.
And are those stipulations cookie cutter or can they be customized to the person?
Customized.
They are.
Yeah, I mean, they've got some broad policies,
Yeah.
but
They
then,
can be customized.
yeah.
Yeah.
We
And
have some statutes that are driving that, but in terms of the day-to-day operations, it comes from central office with their policies and directives.
I'm glad to hear that.
no, and it's good. And I would love to go into depth and I would love to be testifying next time on that, going into depth, because we're looking at our life sentences and moving them, out of the prison and into the supervised community. Now let's talk a little bit about the expenses of incarceration. I noted during the walkthrough that it was noted that on the first page of the bill, the cost of incarceration per person is listed as $134,218. I wanted to clarify for the committee where that came from. So there is a fabulous nonpartisan research org at the national level called USA Facts. They're accountants, writers, researchers, and they scour all publicly available data to do their calculations, and they do their calculations on a number of things. So if you have never heard of them, I highly recommend them. However, I do want to be respectful and note that the Vermont Department of Corrections, on a report that they issued in January 2023 about the 2022 fiscal year, they noted the cost of incarceration per person at $95,292 dollars per person. Wow. Haven't had enough coffee yet this morning. So I can't explain the variation between those two sets of numbers because I don't know the internal processes of each, but what I can assure you is that both sources are considered reliable and credible from a research perspective. So let's look at the math, and I've put it on there for you. By the DOC calculations, 212 lifers at $95,000 per person equals an annual cost of a little over $20 million. By USA Facts calculations, the annual cost is $28 million. Now, the reason I'm not so concerned, I'm a little more cavalier about the numbers here with the dollars and cents, is because this is the floor. Both sets of these numbers are the floor. This number is only going to go up when people have chronic medical conditions, unexpected surgeries, cancer treatments. So either way, you're looking at an incredible amount of money for your lifer population.
So sorry I missed part of this.
Yeah.
Sending a text. So that 95,000 per person, that came from our DOC.
Yes.
And that is the average, which includes all of our facilities, I'm assuming. So the smaller your facility, the higher the per capita cost is. So we have some facilities that have 100 people in them, some that have 200, and then you get to 350, 425. So this is an average. Does that also include their health care at that point, the 95,000?
So I believe that the way the Vermont DOC calculated it is a reflection. So for them, this would include what they spent
What they
in
spend.
fiscal year 2022 on average. Yeah. It only gets more expensive as people go.
Either number is huge.
Yes.
Yeah, so I mean,
Joe?
the numbers we've seen for this fiscal year are 107. That's what DOC testified to, and we also have, I think I proposed 15% budget increase.
So this
Yeah, which would
is,
make it 123, but to point, they're all a lot of money.
so this is, that's right above your head, Joe, but it's 2023. That's the date that this is.
Well, so it was Isaac's presentation in January 23. So it was for fiscal year 22.
So we're talking fiscal year 26.
Yeah,
So some of that is inflation,
yep,
due to whatever.
right.
Well, and in terms of the discrepancy, sorry, Chair, between the two numbers, is it possible that USA Fax is not counting our folks down south? Like, would they only?
It is quite possible.
Yeah. 'Cause
That
affects the
could make
price a lot.
sense.
Yeah, it is quite possible. They could have different timelines for when they did the calculations, running fiscal years differently.
Right.
I'm sure that they included different areas of scope or didn't include certain areas of scope.
That would also include programming costs too.
Yep, everything per person, yeah. Which we obviously don't want to get like the South, but I'll leave that conversation for another time. So we have the issue of an aging prison population, which has potentially aged out of crime. They are statistically lower in terms of recidivism and public safety risk, and they cost the state a tremendous amount of money. Those factors are huge driving forces behind the Second Look movement across the country. So Second Look across the country takes different forms, and I brought a report for you all if you want to go in depth, because the appendix will actually break down the statutes and the requirements of each state's Second Look policy, because they're all different. But Connecticut, Delaware, Maryland, Oregon, Florida, North Dakota, and Washington, D.C., they allow for sentence review under certain conditions, such as the age at the time of the crime. In D.C., for example, under the age of 26, you can get a second look. And or serving a certain amount of time already. So in that case, a person has to have already served 20 years before they can get their review. The asterisk that's on Maryland is because Second Look legislation just passed last week. And so it's waiting for the governor to sign off. And it's additional Second Look legislation down there. California, Colorado, Oklahoma, they target their sentence review towards certain populations, such as survivors of domestic violence or military vets. And again, the asterisk, Georgia, just last week, passed brand new legislation that is awaiting the governor's signature. California, Illinois, Minnesota, Washington State all have statutes that allow prosecutors to initiate resentencing. And California's version of that actually also allows the DOC to petition for the person to be resentenced. The remainder of the states on the chart have judicial rulings that have basically tackled the issue of life without parole for emerging adults. So it's either made juvenile life without parole unconstitutional or juvenile life without parole up to the age of 20, 21, 22, depending on which state you look at, requiring that state to resentence that person. And again, I brought a report for that. In conclusion, so we have a problem. Very large life sentenced population that's stagnant. It doesn't have a lot of opportunities or pathways for review to see if we could release them at various points in their incarceration. We know that people typically age out of crime by midlife. We know that people who have served lengthy sentences are generally safe to release, of course, varying person to person. And the issue of the aging prison population is only going to get worse. I can tell you I have a Google alert on life sentences, and every day my email box is full of people being sentenced to life everywhere. Second Look is a thoughtful review process. It requires the person to serve a minimum amount of time. It requires a judge to look at that petition and make a decision. Will I accept this for review or will I not? And they can make that decision to not. And then when they have the person in front of them in the bill, you'll see there's a whole list of things that the judge is going to take into consideration, including the statements from survivors if they want to testify, prosecutors if they want to object, things of that nature. And then the judge may or may not choose to reduce their sentence, maybe by 5 years, maybe, by 10 years, maybe change their life without parole to life with parole, in which case they would then, I'm assuming, based on the statutes here, need to go through the parole process here. So this is a very high bar that people would have to meet. But we have found from the research that these individuals are worth a second look.
So it's within the courts that determine whether or not the person's sentence is decreased, whether they be eligible then for parole. It would be up to the court and the judge based on facts or factors that were presented at that time of the hearing.
Right. What we're looking for is rehabilitation. Obviously, not to interrupt you, Chairman.
So the question is, who would petition the court for that review? Would it be DOC? Would it be the state prosecutor? Would it be in conjunction with DOC in the prosecution? Because we already have some things in place right now in terms of, and I'm thinking of home detention. Because it's home detention is determined by the courts, but it's upon petition from DOC. And I think also state prosecutor as well as the defense counsel as well for that. So we already have some form of that instructor in our statutes.
I will also throw in an unusual or a rare occurrence, but it does happen in Second Look. The other great thing about Second Look is it allows a person to present evidence of innocence when the Innocence Project doesn't have the capacity to take somebody's case. And if a judge were to receive that petition and they were to receive, additional evidence or whatnot, it would be compelling then for that judge to, say, okay, we're going to take a look at this. We're going to review this case. Because I think most people assume that if you have evidence of innocence, that there's just a pathway back for you into court, but there just isn't. And so we have in Rhode Island, actually, we've been using that. We have an innocence case down there that they're just refusing to take. They just won't look at it, even though they have an attorney. Second Look would be a way to get to the judge through another mechanism to make that case.
Joe and then Connor?
But page 4 speaks about the petitioner,
It's
and the incarcerated person. And it's very vague about who the petitioner is. I suspect that's intentional by whoever drafted it. That I wasn't.
I dropped it.
Oh, I'm sorry.
No,
I'm
it's fine.
sorry, but I suspect you left it vague on purpose. Because there are various parties that could file a petition.
Or I was going to say, or I was writing 6 other bills at the same time. But I think in other states, it varies dramatically. My recommendation would be a combination, that it could be the person can petition, because I think them being able to make their case to the judge is important. But I think it's powerful if the DOC were to feel that a sentencing review, you know what I mean? I think a recommendation from the DOC or from a prosecutor would be extremely powerful, because those would be very rare. And based on experiences in other states, they would not be happening very often. But it's obviously, I leave it up to the wisdom of the committee. But
so the way it's written is it's the person who's incarcerated would petition. It's not DOC. It's not the state prosecutor. It's the person who's incarcerated.
Page,
Top of page 3.
yeah, look at line 19. It does open up on page 3. The name of the petitioner, if different than the incarcerated person.
The petition shall include the name of the petitioner,
and I think
different than the incarcerated person.
So
So,
that means somebody else could be doing it on behalf.
right, but if you,
Right.
medical is an example of that.
what do you mean medical?
If somebody was incapacitated and somebody was writing on their behalf.
Right, so it could be a guardian.
Yeah,
Or
exactly.
power of attorney, or,
Exactly.
but that's not clear in the top of page 3B. Notwithstanding any provision of law to the contrary, an incarcerated person may petition the sentencing court for a reduction of the person's term. So it's silent in terms of
Other people.
line 19, in terms of how you get there.
From an intent perspective, I think it's good to leave open who may be the petitioner.
Well, we'll take further testimony on all this and work through. Let's just get the basic understanding of the second look and see if the committee's interested in doing further work on it. And then we really do set up more testimony to work through the language in the bill and work through the practice that's occurring. There's a lot of practice in place right now in the state. Because we do have the furlough mechanism, we have parole, We have different types of furlough, one of which is medical furlough. We also have medical parole and how all that would tie in. And also it's to look at, I'd like to know what the convictions, what the conviction was and what their sentence, because we have minimum and maximum for the most part. Other states may not have the minimum maximum. They have a determinate time of that sentence. Our sentencing is not determinate because we have a minimum and we have a maximum. Other states, you're in for 10 years and then you're out. There's nothing in the middle. So we have a lot of off ramps when a person is sentenced. So that's what the committee needs to understand is what are those off ramps and then how that plays in if we do a second look. I mean, that's what I'm trying to bring together here for us as a committee. Connor and then Kevin and then James.
Okay, thanks so much, Dr. Reese. This is really helpful testimony. Two questions. I guess one worry I would have is, 15 years goes by and maybe you don't have like an active family member or advocate network. Maybe you have a serious, mental illness or cognitive impairments. I would worry about people getting left behind. Is there an automatic sort of trigger that the person is notified that, 15 years is up, you can petition at this point, because I could just see somebody waving out and never even know it, So that was one question. And then I was just wondering how you arrived on the 15 years and if that was consistent in other states.
So the arrival point is that we have found from the research that anything beyond 10 years doesn't make sense. You public safety wise, money wise, when you sort of combine it, I'm looking for the phrase diminishing returns. That's the phrase I'm looking for. Anything beyond 10 years of incarceration, even for murder, other violent crimes, you're getting diminishing returns. So most states for a second look are not willing to contemplate 10 years. That feels too low to them. And so we have a variety of years set up in second look legislation, depending on the culture of the state and actually the specific problem that's at hand. Who are we looking at here? For 15 years is going to be significant for many people.
Got it. Thanks.
Yeah.
And anything about the sort of notification that happens in other states?
I'm making a mental note of that because I thought I put it in there. And if it's not in there,
Might be.
usually it's like a flag where it says on day such and such, the DOC will notify the person that they're eligible to
Page-
petition for this.
Page 3.
Oh, okay. I'm sorry.
No, don't be
Sorry, on
sorry.
line 6.
I appreciate your wanting to make sure people know. We usually put it in there for that reason.
Written notice.
Mhm.
But the
Line
question
6.
though, that Connor brought up, well, it would be to the court, the prosecution and the defender general. So they could be speaking on behalf of a person who has dementia or
Yes.
incapacitated in some way.
Right.
No. Kevin and then Troy?
I'm good.
Okay.
Have you
Kevin
ever
mentioned-
seen a summary of the recidivism for all those various off ramps, like you say? I mean, over the last 5 years or since the law was changed, 2% of the furloughs have.
That would be a question for DOC, because it's over a 3-year average of someone being out is what determines I think we're at 33%. We've held pretty stable, I believe. But that would be a question for DOC. And I know that there is, I think it's in Judiciary Committee, or maybe it's more in the Senate. They're really looking at how we calculate our recidivism rate. There's a look, because we put that in place. We put that in place over 10 years ago. So over 10 years ago. And I know Senator Sears worked a lot. And it's an average of a person over a 3-year period of the person being outside, being out on furlough or parole.
But that would be a DOC question.
That's definitely DOC.
I think that would be very helpful.
I think it runs around a third, 30%.
Yeah.
That
But recidivism is so tricky.
it's very tricky. It's defined here in Vermont as creating a new
which is
a
good.
new crime. In other states, that's not the definition.
Yeah,
So you got to be careful when it's not comparing apples to.
it's true. It's so true. And so because I focus on extreme sentences, generally what we find for homicide, if you have committed homicide and then you are released, the statistical average, chances that you would commit another homicide, about 2%.
You already got rid of your problem. That's what DOC says. Get rid of your problem. If you're in for murder, you took care of your problem.
But you said the recidivism for another homicide is 2%?
Yeah, when you
Not
average
just-
it across the country in a variety of studies, yeah.
It's still 1 out of 50, so if it's defined as another, I don't mean to make light of it, but
Yeah.
that's pretty high, right, compared to the general population.
I would say, so it's not when we look over time, because our murder rates have been going down, 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 down for the last decade or so. I think our risk tolerance for releasing people is very culturally dependent. And we seem to, as Americans, have a very low risk tolerance. So when something, if I may, when something happens, there's a big explosive sort of reaction. One of the reasons that the problem we have in front of us today is the result of those reactions. Something happens, this thing was horrible. Now we're going to put this law in place, or now every time somebody else does this, we're going to sentence them to life without parole. Whereas before, we would have sentenced them to life with parole, knowing that they can be rehabilitated,
So a point in case.
Yeah.
It's the murder of the young girl in Brookfield, Brooke Bennett. A point in case, and that happened back in 2010, 2012. And our sentence length for sex offenses went up
Yeah.
because of that.
And
So that's a cause and a reaction.
and it's not just this field either, by the way. Like, things happen in society all the time and we react.
I
You
agree.
know, and we do go to one side or the other. The only thing I would say, like, as far as just like there's, murder, I think in many cases you might have somebody, not that it's right, maybe somebody you're very angry at, you murder somebody, or something happens. But then I look at this and you got to go with your own moral values. But as far as I'm concerned, I don't care if they're rehabilitated or not. Child molester should never be out of prison. But I mean, that's like a discussion we'll have to have. But like, there's certain people that I'm sure each one of us has somebody that we say that particular thing shouldn't be eligible. But so something to work through.
We'll work through the testimony. Sean and then Brian.
Thank you, Dr. Reese. It's actually fascinating, but I'm just wondering about victims.
Yes.
And how is there any data?
Yes.
Okay, on how they feel about Second Look?
Well, not Second Look specifically, but we do have a 2022 Survivors Speak report that I usually, when I'm testifying as a survivor, I usually bring that data with me. I'm happy to share it with the committee. It's a very good report. And it basically shows that the majority, like, depending on which piece of it you're looking at, 2 out of 3 survivors want the system to focus on rehabilitation versus just really long sentences, and like, I think it's 66%, don't quote me, but it's something like that, of survivors that absolutely support the idea that somebody can earn their way towards a second look. So if they're active with their education, their job training, their drug counseling, their therapy, their whatever, if that person can demonstrate that they are doing that, that survivor is in support. And these are survivors of violent crime, like, included in these conversations. So yeah, I'm happy to send it to the committee. I usually bring it with me. I got it, but yeah.
Brian and
It was
then.
the same line of questioning, and so I'd love to see that too. We had testimony earlier this year about, not Second Look, about a good time or time served. And there was some concern among some victims and victims advocates that there hadn't been truth in sentencing, right? It's going to be 10, but it's only 8 or something like that.
Mm.
And it seems like it could hit the same chord. But yeah, so same request as Sean. Yeah.
Well, and truth in sentencing is actually one of the major reasons that we landed here in the first place. Truth in sentencing is like a 1980 policy. The woman who, I believe, one of the first people who started advocating for it is actually in New Hampshire. And so this truth in sentencing is one of the reasons we're here. Survivors, the situation with survivors is really challenging because as a survivor myself, I know that everybody's journey is different. And I don't believe anybody has the right to tell a survivor how to feel. And at the same time, I know that restorative justice brought me healing.
Mm.
And that I have actively had to look for my own healing as opposed to just relying on the incarceration of a person. So I'm hoping that as we move into this next phase in our society where we're looking at this overall picture, that we can find better ways to take care of and support survivors. It's one of the reasons that this bill at the end has the reallocation piece. Because when I worked with Robert McGuire on this, I asked him, I said, can we reallocate at least a portion of this savings to support survivors? Because I almost lost my job because I couldn't show up. I was calling out of work because I had PTSD. I was having nightmares and flashbacks, like night after night after night, waking up thinking that I was being choked. You know, I couldn't afford therapy at that time. I was at a job that didn't give me health insurance. I couldn't even, so I had friends and I had family to support me. But I could imagine if I had friends and family who were telling me that he should rot in prison, that I would then take that mentality as like, oh, that's what needs to happen in order for me to be sane. But it just isn't. It would never be for me. That would have never worked.
No, understood. Yeah, thanks.
Kevin and then Will.
If you're not comfortable answering this question, I fully understand, but is your assailant still alive?
Yes.
And so,
And he has a family.
I'm sorry.
He has a family.
And
He's
so.
working, has a family.
Restored.
Yeah, we have not had much communication. He was released in Massachusetts and then went back to his home state in Pennsylvania. And so I have seen him on Facebook. I've seen, what he's up to and things like that. And even though it was a really horrible situation at the end of the day, it changed my life in a way that, like I said, brought me here. And so I'm grateful. But yeah, he's still alive.
God has many ways of doing things. But you obviously, since you're advocating,
Yeah,
believe that it was the right thing to do for him to be released.
I do. Yeah. And then when I started doing restorative justice inside the prisons, so I've facilitated in 7 different prisons, 1 women's
Could you
prison.
explain what restorative justice is? Because again, this is new terminology for a lot of folks here. So this is we have restorative justice here in the state as well.
I know I work with your advocates. They're lovely people. Restorative justice is a philosophy that hurt people. And so when a hurt person has hurt another person, there is like a tear in the fabric of the community that has happened. And therefore, the mending of that fabric is not to simply just take somebody and incarcerate them, though incarceration may be a part of what they do as a part of punishment. But the real work and the real healing comes through dialogue, either with a surrogate or with the actual person themselves. So like, for example, with my assailant, if we had done restorative justice together, I would sit down with him face to face with other people in a circle, and we would talk, and I would get to ask him questions. I would be allowed to ask him all of the questions that many people wish they could ask. Why did you do it? Are you sorry that you did it? Like, have you changed? There's a lot that people who have lost loved ones have told me they would never be able to, the information could never come from any other source other than the person that took the life of their loved one. And so being able to have that direct conversation, which is really powerful, for me was transformative. I decided to become a restorative justice facilitator when I sat in the basement of San Quentin prison with a group of men, all of whom had taken life, and shared with them my story. And then they shared with me like what they felt about it, their reactions to my story, their sorrow that I had lived through that. And then also some of the violence that they had lived through as young people as well. And that makes everybody in that space, I think, a little better. Doesn't make it right, but it makes it better. And so after my assailant was sentenced to 7 to 10 years, 10 years, 7 minimum, I was horrified. I didn't want him to go to prison. I had asked the DA to not pursue the case. She said she would subpoena me and force me to be on the stand to testify if I refused. So I was young and didn't know what to do. So I did. And then he was sentenced and he went away. And all I felt was guilt and horror. And I wondered, did he care about what he had done to me? Was he sorry? That's what I wanted to know. So then when I started doing restorative justice, fast forward, doctorate, restorative justice facilitator, and I'm in the spaces with all of these people inside. It's really hard for people in society to hear this, but people who are serving life without parole and really long sentences, the overwhelming majority of them are sorry for what they did and are either trying to be rehabilitated or are definitely rehabilitated from a forensic psych perspective anyway. That was a long-winded answer. I apologize.
No, it was very helpful, and I could see the difference between premeditated and.
I'm a passion. We call it.
Yeah.
Yeah.
I appreciate that.
Thank you. Thank you, Chairman.
I'm glad you mentioned the victim fund, because yesterday when we asked about justice reinvestment from the federal level, there was no money that was being directed at least in that way. So I'm glad to hear that you mentioned that.
Thank you.
Yeah, I guess probably shouldn't talk politics too much in committee, but I was just wondering what the sort of fight was like to get this bill over the finish line in some of those other states. What was interesting to me was, some of the states highlighted on your map there wouldn't typically be like, really lefty states, right? So,
Yeah.
was there a lot of opposition? Did people duke it out in the state house? Has there been efforts to repeal it, since? So just kind of curious.
I would say I was not intimately involved in all of them, but from a standing back and knowing all of the players who were involved, I would say generally this stuff is an uphill battle with the prosecutors. They have said before that they get it right, that that everything that they do, they get it right. We actually had that happen in Connecticut, where our other second look legislation is pending right now, where they said they get the cases right. So that tends to happen across the board, that the prosecutors are opposed. And then we get these places where, so DC is a great example. They have been really progressive on this stuff, on these issues. Maybe progressive is the wrong word. Forward thinking. I think they've been forward thinking on these issues. They were the first to pass second look for emerging adults under the age of 26, with just a minimum of 15 or 20-year sentence requirement. And DC then went on like a year or two later to abolish life without parole. And the federal government came in and said no, and took care of that. So they tend to move in a future-oriented direction in these types of issues. Then the other places, it's all about who comes out to support you. If you have a survivor who's really high profile, who wants something like second look, that is really helpful. The politics of it. And then some of the specific domestic violence survivors, for instance, and the military vets, for instance, to me, they are the beginning of heading towards this, because those two categories are basically saying, we acknowledge that in the context, which is what you were referring to earlier, the context of the crime matters. And if these people were in a domestic violence relationship and the crime occurred in that context, these states are saying like, well, those sentences should be reviewed. Not that the person never does prison time, but that they're reviewed. Or if you were a military vet and you have PTSD and you have a flashback, snap reaction, and you kill somebody, we now understand better the context of the crime. But to me, that's us slow walking towards the real thing, which is all violence happens in a context. And shouldn't we be reviewing, or at least thinking about reviewing sentences at some point for everybody, rather than just sending them into a black hole to die? But that's just my hot take.
Thanks so much.
Yeah.
So what has happened where a second look is in place? And say the court really agrees that, and maybe the person should be released. It's not always decreasing the length of time left on the sentence. It's saying, okay, you really should be released. What happens in a situation where there's no place to release the person? Has that come up?
It has come up and other states have, one second look has passed, there has been a whole implementation phase that usually involves more heavily the Department of Corrections, the judges.
What do you mean by implementation stage?
So like if this bill were to pass, I think that our effective date is probably that's listed on the bill is too close. So we would push that out. Some other second look legislation has pushed it out even further.
When the
To
law
allow-
is effective.
Exactly.
I'm not talking about that. I'm talking about when a person reaches that 15-year, whatever structure it is.
Yeah.
And the court is looking at, should the sentence be decreased? And could the person be released?
Right.
And there's no place to put the person.
Right. And so what we have done is when the statute has passed and it goes into law, we then have worked with Department of Corrections, judges, things like that, to come up with the plan. What's the plan? Like, do we want to not statutorily require, but rather administratively require a process? So maybe the DOC would suggest, if the judge comes to this conclusion, we're going to then ask for, 180 days to make up their plan or a full year, or I don't know if you have step downs here. I've seen some places have said that when they have reduced your sentence, they can step you down to like a minimum.
You need a minimum sentence.
Facility, yeah.
No, our facilities have both minimum and medium.
Got it.
For that. So it just depends how many walls of separation between the person who's incarcerated and the outside. That's what's determined. And what determines a minimum or medium? It's really based on the offender's behavior while they're incarcerated. It's not based on their conviction or their crime. It's based on their behavior while they're incarcerated for that. So we don't.
Yeah.
The only thing that we're possibly looking at is for the women's facility. If and when we ever build a new one, they would have an incarcerative facility. And then they would also have a separate facility that's called reentry for folks who have served whatever length that they maybe 2 years out from meeting their minimum or a year out from meeting their minimum. They have participated in the programming that was required. They've been a offender who abided by the rules while they're incarcerated, and they could qualify to be in the reentry building, which then would allow them to leave the facility possibly on a day-to-day basis and then come back to the facility. So that's what we're looking at for the women. That's long-term, and the men, we don't have a structure like that yet.
Makes sense. Yeah. So any recommendations that you have the committee has based on state, on this state specific, how we would want to implement,
right? Because I know one thing, right now, a lot of folks could be released on medical furlough. A lot of folks could be. There's just no placement for them. That's one of the issues. Some folks should be in a nursing home. Right. Nursing homes, particularly if it's a sex offense, will not take them. And sometimes, families are not capable of handling the case, the situation, the medical situation of the person, or the family is the victim and they don't want the person. So that's where I'm coming from. How would a court deal with that?
Right. And I think we would want to, I have a great relationship with the DOC here too.
Mhm.
And I would definitely be interested in speaking with them and partnering and saying, what is it that we can do? And I think it would have to be a case by case basis, obviously.
Because we already have that mechanism in place, so to speak.
Right.
Because we do have the furlough piece and we have medical furlough, and we also have the parole piece, which is medical parole. So we already have those little mechanisms in place. Not to say that we shouldn't look at at second look, which is it's another tool in the toolbox.
Right. It's like, can we plug it all into the same like pathways that already exist? Yeah.
Are those off ramps available in Vermont for people who have no opportunity for parole? Or maybe
We don't, most of our sentencing is minimum maximum. We don't have that many. 14. Yeah, 14 out of 1,200 people who are incarcerated, 14 people life without parole.
Right, so
It's pretty minimal.
so the opportunity for this program in Vermont actually is minimal. Because they all have opportunity for parole.
Furlough. If they have,
Yeah.
if furlough kicks in when they've reached their minimum,
Right.
and then if they're furloughed out at their minimum, and they're successful, they could be paroled. We've also put in a few years ago that when a person has reached their minimum, they are presumed to be paroled. So they don't have to do the furlough step. They are presumed to be paroled, and DOC has to make the case that they are not a good candidate to be paroled. Some folks, when they reach their minimum, could go right into parole.
Right. But this bill, if I may, is designed to look at potential sentence reductions. So rather than waiting for somebody to get all the way to maybe when they're too old, and now we're looking at an elderly infirm.
To reach their minimum.
Right.
So if their minimum is 20 years, they've served 15 years. So upon that 15th year, they could petition the court for a second look at their sentence.
So, and I'm not saying your recommendation is wrong, but if we just change ours so minimum of 15 instead of 20 years, you've accomplished the same thing without a third program.
Well, it's not us that makes those determinations for everything. In our statutes
Yeah,
that
well,
comes
that's
through
what
the
you said.
sentencing commission
Right.
is for certain crimes, what's the sentence? And there's minimum maximums. That's set in statute. But it determines when it goes through the court proceedings, it's the judge that makes the determination
Right.
for that within the confines of the statute for that particular crime. But those statutes are derived from the sentencing commission that we have. It then goes into state law.
So many layers.
So it's up to the court when they sentence someone to what it is. So we can't go say, well, every minimum's gonna be 15 years, because we have minimums that are 5 years, but you could have a maximum of 20. So we can get into that a little bit with DOC. I think we would need to, so folks can really understand how it plays out.
One more curious question. I think I saw the state of Washington has all three situations.
Yes. Yeah,
So
because
county by county, they,
no, it's 3 as in they have a judicial ruling that makes LWAP unconstitutional up to the age of 21. That's the Monschke case. So that's judicial. And then they have legislation that is second look. And then what was and they abolished JLWAP. So those are the 3. Yeah. Yeah. Because this is all about addressing the large life sentence population. And what are the ways that we can address the large life sentence population? Yeah. So
it's not regions of the state.
no.
They're handling in 3 different.
Yes. Yeah.
Wow.
They led the way. They did the Monschke case before Massachusetts did their case last summer.
Sounds like us. We've got multiple off ramps.
Yeah, which, from a life sentence perspective is very good.
No questions, comments, Dr. Reese.
Taking so much of your time. I
No, that's
appreciate all of
That's
the
it. Thank you.
opportunity to talk to you all.
Thanks,
Thank
Dr.
you.
Reese.
Yeah,
You
you,
have someone else from your organization too?
yes, she's had a medical emergency.
She's not on Zoom?
I didn't see her.
She's not on Zoom.
Okay.
I did not see her. She's done a lot around the country too, so.
So I know we have some other folks here that, I don't know if you'd be interested in testifying, either one or not. If you had planned on it, or just in to hear the testimony from Dr. Reese. I just want to offer while you're here, if you would like to testify, I'm not asking you, forcing you to, but Tim, you want to come on up? And if folks don't need to take a break, take a personal break. But Tim, I'm just briefly,
Very briefly, my name's Tim Burgess. I am the co-chair of Drop LWOP New England. I'm the executive director of Vermont Cure. I 100% support this legislation. And, obviously, I think a lot of legislation around the country has significant carve-outs. I've heard a lot about sex offenders, things like that. And I would ask the committee if there are any questions for me to feel free and ask.
questions at all? Sean and then Brian.
I mean, why are you so passionate about it?
I've been incarcerated. I work very closely with people who are incarcerated, who are serving extreme sentences. And I know the positives and the negatives of having served and incarcerated with people who have, as Dr. Reese pointed out, grown out of their misspent youth. So, yeah.
And then a follow-up to that, and I guess this is for Dr. Reese too, but is there some correlation between having the victims meet with the perpetrators and come to some kind of that's almost like that part of forgiveness and the restorative justice, is that kind of baked in here too, or not? Is it loosely just giving money at the end of it?
So I'll let Dr. Reese attest to that, but as a person who had a victim, I know that baked into the program that's happening.
Programming within corrections.
Within corrections, thank you. The programming that happens, there is the baked in victim empathy piece. And in my situation, when I went in front of the parole board, there was no question that it was very, very centered on, you created this victim. Now, how do you reconcile with that person? So I don't know if that answered your question.
Well, is it official? Is that part of the process? It almost seems like that needs to be, if the victim wants to hear it or be part of it, that should be part of, to me, I don't know, it just seems, I don't know a lot about it, but
that should absolutely, in my position, from my personal opinion, absolutely be part of the process of pulling the victim into the discussion, should they choose to want to be. That's another big piece of that. And saying, where are you here in this process? I don't know if you wanted to say anything else for Shawnee on that?
Yeah, I'll just, standing up because I'm too short. I'll just add that I think that making services more available, more options available to survivors who want to participate in these things is a beautiful thing. And Vermont is really far along in comparison to other states in terms of having restorative justice available, having very talented facilitators and a DOC who's open to it. I think most of the survivors don't know what it is, nor I think initially the reaction when you've been hurt is to be like, are you kidding me? There's a lot of anger, there's a lot of rage. And so then finding ways to really connect them to another survivor who has done it, maybe one that they would trust or something like that. But I love your suggestion. I think in addition to reallocating resources, if there's a way that, we should talk to the DOC and see how we can make it happen. Because it's a beautiful thing. There's not a correlation between, we don't know enough directly about if somebody met with their perpetrator, do they support second look, for instance? We don't have that those connections yet, but it's also because we don't have a culture yet where what you're working towards is healing and healing, I should say accountability first and foremost, healing and maybe forgiveness if that were to ever be on the table for a person. But it's so delicate and case by case and people don't trust it. You know what I mean? So I think.
And yeah, and I've always been a believer that when you say sorry and mean it, it really does move a relationship and something healing forward. So that's all I'm.
I know, I completely agree.
If I may address that last comment you made, it's not only apologizing, it's meaning it and showing that you have truly, that you're going to take actions not to be in that seat again,
Once you've been held accountable.
once you've been held.
I think.
Yes.
Brian and then Kevin.
No, I'm fine, thanks.
Okay, Kevin?
No, it's more of a comment than anything else. I would think that if you and your offender were able to come to a forgiveness situation, that could offset the need for punitive action. But if that can't happen, then the victim, I would think, says, no, the minimum sentence is required, because that at least that, it's not a question. I'm trying to understand the mechanism, and it's too complex to.
I think that's just it. What you said is exactly right. Complex. It's so complex. Because I think that it's hard to comprehend that restorative justice and incarceration, like hand in hand, is oftentimes the necessary thing. So if somebody has taken a life, I always recommend don't try to do restorative justice until after a decade. Like, unless you're just there naturally, like but if you are a person who has most of our reactions after you've lost a life is to be so, oh my God, enraged and just hurt and devastated. So the courtroom where the trial is happening and all of that is not the time to try to bring people together to have a conversation about it, So incarceration for a decade, which again, we know is research-based. Okay, that's part of punishment. It's also, as Tim says, a part of learning your accountability and really figuring that out. And then if a survivor is interested in having that conversation, facilitating that conversation, I'm telling you, I didn't really believe in God, if I'm being honest, until I sat in those spaces and witnessed the healing between, a mother and father who had lost their son to gun violence and the young man, now no longer young, who shot him.
Gotcha.
Yeah.
Other questions?
Here's your answer.
Comments? Questions?
Thank you.
Thanks, Tim.
Thanks, Ted.
Anyone else that would like to come up or not? Meg?
I've just very briefly, I have not much to say, but I'd be happy to say it. Sure.
Come on up to the hot seat, Meg.
Oh, that's very tight. Yeah, sorry.
If you could identify yourself.
So my name is Meg McCarthy, and I am here because my husband is a person that could potentially benefit from this bill. The chairwoman probably remembers me coming before this committee so many times, trying to promote ideas about any bill that would give my husband some relief. He is in his 14th year of serving a 17-year sentence. He will be 76 when he is released. And he is not a danger to anybody. And that's why I'm here, just because I support this bill. And I would like, in addition to thinking about the victims of crime, which of course is a very important thing to think of, also think about the loved ones of the people that could benefit from this. Not all of them have burned their bridges. A lot of people still have people that love them and would like to see them back in their homes.
Thank you, Meg.
It's Nate.
Thank you. Anything else? Sure.
What's the best way to get these?
Just give them to me.
Pass them around.
Give them three different reports for your.
Here's the.
I don't know if Connor can.
Just split it in half.
That's a lot for me. That's a lot for
Split
me.
it in half and then half goes one way, half goes the other. Dr. Reese, I think your testimony has been very, very helpful. We'll spend time, what I'd like to do is a quick 10-minute break for the committee and then come back and just see where the committee is at in terms of wanting to, if they want to do further work on the bill. And if they do, let's set up further testimony.
Actually, the third's coming.
Great, okay?
Is that it? Let's go.
Thank you. So let's go out.